Brunswick Library. My name is Ken Vercammen. I'm an attorney in Edison, New Jersey. And, I miss doing the programs live, but hopefully I can keep talking and entertain people. And we kind of start off typically with, many times people would ask, if I was at a social event, hey, Kenny, by the way, why do I need to have a will? I'm married. Doesn't everything go to my wife? And I goes, well, that's not really doing planning. That's just hoping that you both live forever. So even if someone is married and everything goes to the spouse, well, that spouse is not going to live forever. So eventually someone either does the will, does it, has it done right, or you just kind of put your head in the sand, But hopefully in the program we'll explain why you want to have stuff properly done. So if someone does not have a will done, or the will is declared invalid because it was improperly prepared or improperly signed or not admissible to probate, kind of bad things happen. So, number one, the procedure to distribute assets becomes much, much more complicated and more expensive. So let's say there's 4 children. Well, it requires all the children to agree and decide upon who's going to be the administrator of the estate. And the children who are not the administrator have to all sign a renunciation affidavit in front of a notary and then pay to have it filed with the surrogate's office. If all the children do not sign the renunciation affidavit in front of a notary, then an expensive complaint order to show cause has to be filed in the Superior Court seeking someone to become one of the family members to become the administrator. So plan on spending at least $3,000. Well, doing a $400 will, would solve that issue. Number 2, where there's no will, the person who eventually becomes the administrator has to take out a thing called the surety bond. Surety bond company's going to charge about $1,000. Let's see. So the person does not save money by not having a will done. And, part of it, hey, you never know when's your last day. People are reluctant to get wills done because they think, oh, well, I'm not sick, I'm not old, etc. Well, you never know when it's going to be your last day. We were very, very busy last March, April, and May. We were doing things remotely, but people thought it was going to be the end of the world. If they left the house, they were going to breathe germs and die. Now, if there's no will, or again, someone didn't have it signed properly, state law determines who gets your assets, not you. And more people are saying, you know what, I don't want to treat all the kids equally. I want to give more to one or the other. I'd rather give it to my grandkids. My grandkids need it for college and weddings. My kids will just spend it on a boat. And now, if someone does not have close blood relatives, the state of New Jersey gets your assets if you have no will. Who on this planet would want the state of New Jersey to get their assets? Nobody. But most importantly, if the will is not done, then it often causes fights, aggravation amongst the family. Let's go over what you want to have done, because again, when loved ones are grieving and dealing with death, they shouldn't be burdened with financial concerns, estate problems, and other issues where there is no will that is done. So think about, who don't you want to get your assets? People that have minor children. Who would not be the best choice to raise someone's kids? If someone has minor kids and both parents pass, a complete stranger determines who gets the custody. I say the bald white guy, who's typically the Superior Court judge. Well, now it's no longer a bald white guy. It's it's a nice lady, but the same thing. You would rather just there's no best person to raise your kids, but who would you want? Now, I also say, beware of these cheap online documents not prepared by an attorney. because the surrogate's office keeps giving seminars how these people are cheaping out. They're not getting stuff done correctly because they're relying upon advice by, a paper salesman, and it costs the families like thousands of dollars more. So think about, you could try to do your own electrical work, but you'd probably do it wrong. If you try to do your own plumbing work and you don't do it right, you're going to have sewage in your house. No one changes their own oil anymore. So it's always best to have a professional done right. And it's kind of a good investment because many times the professionals say, what about this? What about this? What about this? People people that have businesses, etc. Yeah, you could use TurboTax, but it's sometimes better if you have an accountant do it. Let's see. People can do their own financial planning, but sometimes the financial planners will find ways to actually save people money. Now, interestingly, COVID has made it easier for us to help people out and prepare documents, because prior to prior to 2020, everyone would have to come into the office and fill out a form and sit with the attorney. And now with COVID, even before COVID, we started making it easier where we would email the questionnaire out to everyone. They would type in who's executor 1, who's executor 2, type their name, who's getting their stuff. They email it to the attorney. The attorney looks at it. The attorney calls them back. They pay the attorney either by check or by credit card. Everything's online. You're not touching anyone. The attorney then prepares the documents, emails it. The attorney keeps calling the people, answering questions over the phone. For a while it was a big thing, meeting with clients via Zoom. Well, I found most of my clients don't need to see my face, or they didn't really want me to see them, because that meant that they had to dress up and they couldn't really do it from, their car or whatever. So people just decided, I'll let the attorney do it. So the idea is we wanted people to be safe, and getting the documents done now is easier than it ever was done before. So let's talk about what you need to prepare the will. Well, let's say I mentioned you're going to type in who's executor 1, who's executor 2. And by the way, we need to talk to whoever we're doing the documents for. Sometimes we get a call, mom or dad needs a will. Okay, listen, I know that they're not that as good with email and the internet. You can type it up for them, but I need to talk to them before we draft anything. Now, executor. The executors are one. New Jersey's a probate easy state, not that complicated. So, the executor is the one that follows up the what you're going to be doing, who's getting the assets, etc. So, again, executor 1, executor 2. You never want to have joint executors. It creates twice as much work. Twice as much. Even if they're twins living together, that means that both people gotta, go to the surrogate's office and sign the papers, and both people gotta meet with the realtor to sign the listing. Both people gotta go to the bank and open up the estate account. Both people gotta sign every single check. Both people gotta go to closing. The idea is trying to make it easier, not more difficult. Now, those are people who get along. Sometimes you get people who hate each other's guts and won't agree upon anything. We had two brothers that brother number one said the sky is blue, and the other brother says, no, the sky is gray. You're stupid. You've always been stupid. So the idea is, again, there's only one captain of the ship. There's not two captains. Let's see. One person's in charge. If they can't do it, then your second person do it. Trying to make it easy. Probate New Jersey's easy. Probate basic. All the executor needs to do is bring, have the surrogate get the original will, death certificate, check for about $150. And now, because the surrogate's office is closed, they're permitting the attorneys to help the clients with filling out the forms and having it certified in the attorney's office. Yeah. And then, believe it or not, New Jersey did away with some of the taxes. They did away with the estate tax completely. So now the only federal estate tax starts at $11.7 million. Let's say I live not far from Farrington Lake, but I think the only people in North Brunswick that have more than $11.7 million are the ones that live in those ritzy houses on Farrington Lake. But you do want to provide your attorney with the list of what the real estate is and a ballpark of what the assets are. We don't need to know what account numbers are, just a ballpark, because again, there's no estate tax, so unless it's more than $11 million, and assets are not listed in the will because we don't know when someone's going to die. Okay, there are certain assets though that pass directly and do not pass under the will. So think of those are certain things passed by way of title. So an example is a house. It's owned by husband and wife, tenants by the entirety, automatically goes to the surviving spouse. A will can't change that. Bank accounts that are payable upon death, joint accounts, joint tenancy, POD. A will can't change that. So even if you put in the will, hey, these accounts get divided equally, but you have one of your kids on that account, under law, it goes automatically to that kid. Now, again, some of the clients have said, well, I'm sure that my daughter would, do the right thing and divide everything equally. And I said, yeah, I'm sure they would now while you're alive, but the problem is that, if you pass, there's sometimes pressure by their own spouses to keep the money. Other assets pass by way of contract. Those are IRA, 401k, life insurance, annuities, anything that has a beneficiary. So again, the will can't change that. And it's a good idea for the accounts that you have beneficiaries on to get printouts that say who the beneficiaries are. And you print out a copy and you put it in your will file. Where do you put the will? And most people just put the will in a fireproof box in their under their bed in their bedroom. That way the family can get to it. Don't put it in a safe deposit box because you can't get to safe deposit boxes on weekends, nighttime, etc. So if you're writing stuff down, a will cannot change who is getting things if there's already a direct beneficiary on them. Now. In the will, typically people put, we ask who's getting stuff, and in the traditional, it says it's going to spouse, the spouse predeceased to children. They don't have any children, then to that person's own kids, their grandkids. But I'd say it's your decision on who's getting your stuff. The only thing you can't do is leave a spouse penniless, but. More and more people are saying, no, I'm not going to do everything, equal. And at one of our clients who went to a seminar said, we have one of the kids we don't hear from much, lives on the West Coast. I go, well, let me ask you a question. On your birthday, did you get a card or a call? She goes, no. On Christmas, did you get a card or a call? No. On Mother's Day, did you get a card or a call? No. Well, then the question is, why leave anything to someone that doesn't care about you? And we know that that's going to be, the biggest person in the way after you pass is they're not going to cooperate and they're going to be the troublemaker. So if someone, so some people say, listen, instead of giving it to my kids, I want to give it to my grandkids because they're going to need it for college. College is very expensive. If I leave it to my son, he's going to go buy a $200,000 boat. My daughter-in-law is just going to buy, spend his money and buy jewelry. So, again, it's your call. Think about, and again, sometimes people don't leave it to blood relatives. We had a client, didn't have any close relatives. She had cousins, but, she left monies to the people that were nice to her. Not because they thought they were going to get a windfall, but because these were naturally nice people. The neighbor that, would always call up, in the snowstorm, hey, Helen, do you need anything? We're going to the store. They would make sure that, they would call up just to make sure that the person was still okay because lived alone. So it's your call and who's going to get your stuff. We have to be very careful to undue influence. That's why when we talk to everyone, we ask, what do you want? And they can't say, oh, it's whatever my son or daughter wants. No, no, no. You have to tell me what you want. So your will sets forth who's getting assets. Some people have what's called specific bequest. What specific bequests are? It's where a person or entity is getting a specific amount of money or a specific asset. So some people might say, okay, it's going mostly to my kids, but $10,000 to each one of these grandkids. Some people say, okay, I'm leaving $10,000 to Our Lady of Peace Church on Route 130. Someone says, okay, listen, I'm leaving money to this charity or that charity. But it should be specific, because I tell people, do an internet search. Make sure that entity is correct. I'm involved with an estate where, if eventually it says in the trust that money's going to cerebral palsy of Middlesex County. Well, we didn't know so. There is no such entity. There's UC. So entities change their names. So try to be specific in who's getting a charity specific bequest. Sometimes a lady say, I want my jewelry to go to my daughter, my granddaughter, because she says, I know if my son's the executor, he'll go to Cash for Gold and say, what do you give me for this junk? Sometimes the guys have their own, their autographed Mickey Mantle, cards, and they want it to go to the, down the generation because they think stuff is worth money. Most of these collectibles aren't really worth what people paid for them. They're only collectibles when you spend money for them. But, and again, if someone wants to type up a list, we include it. It's not a handwritten thing. We want to include it in the four corners of the will. Now, in addition to specific bequests, sometimes we have what's called a reverse specific bequest, meaning I leave nothing to this person. We don't give a dollar, not a reason. Why reward someone that never thanked you for, cards and etc. One guy wanted to contest a will because, he wasn't getting his half of the will, and it turns out that he had sent his mom, a letter said, you're nothing to me. I don't want anything to do with you anymore. Well, he got his wish. So again, it's your right to do what you want. Now, when there's kids, well, we always have a clause that says no one under 21 gets money, because 19-year-old, 21-year-olds don't spend money wisely. Sometimes for the kids, though, when they're younger, we have a clause that says no, none of them get any money outright until they're 22, 25, and 30. But the executor who becomes a trustee can spend as much money as is needed for health, education, maintenance, college. Well, hey, the University of Scranton in Pennsylvania costs a lot more money than going to College of Morris or Stockton or Rowan. So sometimes people say, listen, I'd rather have it going towards these younger kids because we believe in education because it'll help them more in the future. But again, protect. If you don't have a will, they get their money when they turn 18, and there's not a single. Not only do 18-year-olds not do smart things, but they're pressured by everyone else to help them buy beer, go to Seaside. The guy's girlfriend, oh, you haven't bought me any nice jewelry for a while. So that's why we want to have when there's a person who the executor typically becomes what's called the trustee. Think of the trustee holds the money. If they're minor kids, the guardian holds the kids. So people put off, oh, there's, I'm not sure who the right person is. It goes, well, there's not too many people on the planet. So when people come into our office, I would say, okay, if you couldn't come home today, who would you trust watching your kids for the next 2 weeks? And they'd say, okay, my mom. Okay, let's put your mom there. Well, she's getting older. He goes, yeah, she's getting older, but she's the best person now. You can always update your will down the road doing a codicil to update it, but think about who you don't want, because if there's no will or it's not listed, the person you don't want can march into before that judge and say, I want to be the guardian. And this is especially true when people might not have that many people in the U.S., but their relatives in, India, Philippines, China, and most people said, listen, I want someone in the U.S. to be the guardian trustee, right? Now, it is very important that there be a clause in the will to say self-proving will. What's a self-proving will? Well, under the old laws, the person signed, the two witnesses signed, but then the executor had to find one of the two witnesses to go and sign paperwork with the surrogate to say they were the witness. And it became very complicated. Sometimes you couldn't find a witness. Like the lady that was the witness to my grandmother's will, like that was done the old way, she goes, oh, my fee's $500. We said, we're not paying you $500. Lady goes, well, get the other witness. Well, she's dead. Yeah, my fee's $500. Well, if we didn't pay the lady the $500, we would have had to spend over $3,000 doing a complaint order show clause to have the will admitted to probate. So a self-proving will, what New Jersey's newer statute is, person signs, two witnesses sign, then the attorney and notary signs, then there's additional language to make it self-proving, and that way the executor does not have to locate the two witnesses. I point that out because a lot of these cheap things we see online are not self-proving wills, and then, what does the person say? Nothing, because then, and if you can't find a witness, then you got to spend $3,000 going in front of a superior court judge. Also, you want to have a clause that says no bond required, because the will does not have a clause that says no bond required. Then the estate has to spend $1,000 on a bond. So also we inquire if any of the beneficiaries are receiving SSI or SDD, because sometimes if they receive assets, they lose their government entitlement. So sometimes instead we set up what's called a testamentary trust, where the kids don't get the money directly to them. The trustee holds it and can spend money. What are some of the clauses in the will? Debts and taxes paid, specific bequest, who's distribution of spouse. Sometimes we don't leave money outright to the spouse. We set up a trust for the spouse for two reasons, especially if it's second marriage. But that way, if it's a trust for the spouse and that spouse has to go to the nursing home, those monies are protected from Medicaid. They're protected from creditors. They're protected from taxes. So you talk to a professional. Sometimes the professionals, can save you money in the long run. Now, if you already have a will, take it out. Is it self-proving? Does it have a clause that says no bond required? And look to see, hey, who's the executor? Can the executor still do the job? Our rule of thumb is the executor should be able to drive to banks, drive to the attorney's office, walk up a flight of steps. If the executor, can no longer drive and can't get around, then there should be a document where there's someone newer. Again, it's not cost. Now, don't be a putter-offer. Get your stuff done. Mr. K was a putter-offer. He was saying, well, I like to read up more. He goes, Mr. K, you don't need to read anything. Let's say, I went to law school. I passed the bar exam. I wrote a book for the American Bar Association on wills and estates. You don't need to read anything. I've read for you. I read these journals and periodicals. And I told him, when I need a knee surgery, I didn't need to read anything about knee surgery. I says, hey, doctor at University of Orthopedics, have you done this before? He goes, Kenny, I could almost do this in my sleep. Okay, good. I don't need to read about knee surgery. Well, this Mr. K, he puts off doing a will. We don't hear from the guy because he wants to read. And then he dies 2 years later. His family finds some communications we had with the guy, and they said, do you have a copy of his will? He goes, no, he never did a will. He didn't want to spend the money at the time. He wanted to read more, and it cost the family tens of thousands of dollars more because at the time they were subject to estate tax. So you don't need to read about stuff. Just like you want to go to someone that's done this before. You sign the will gets signed, and nowadays, same to make things easier, we have it so people can sign at the UPS store or notary on the weekends or nighttime. When the state was shut down, the UPS store was the only thing allowed, one of the few things allowed to be open. The banks were closed, but they have notaries there. Once you have your original will, You let your family know where it's at, where the executor can get to it, and it's yours because it's your property. It's not the attorney's property. Periodically, we get calls. Oh, my mother-in-law used to call me. I like to come in and get a trust done. I go, were you watching Susie Orman again? She goes, oh yes, I love Susie Orman. He goes, hey, Susie Orman is very right if you live in New York, California, Florida, where probate is very complicated. But New Jersey is a probate easy state. So I ask people, why do you think you need a trust? Well, to avoid probate. He goes, I go, doing a trust is going to cost you $3-4 grand. Probate costs you about $150. You're not really saving money. I'd say, also, sometimes people say, well, I want to protect my assets. Well, a revocable trust does not protect your assets because it can be revoked. It has to be an irrevocable trust. A revocable trust does not protect assets from Medicaid, nursing home, or taxes. Some of the trust salesmen talk about, well, a trust is private and no one knows your business. They goes, well, what do you care if your kids or grandkids or families getting it? Unless you're giving it to like the Ku Klux Klan or terrorists. What do you care if the will's a public record? Say, oh, Jackie O is a private person, but her will was admitted to public probate. Yeah, she left it to her kids. What's the big deal? Also, if you're doing a trust, that means that your assets then are owned by the trust, and that means new deeds, affidavit of title, residency, certification, a whole bunch of papers are got to be. Now, there is a document that some people do to protect their assets from Medicaid. That's called an irrevocable trust. So an irrevocable trust, again, the assets are put into the name of the trust. You don't own them anymore. You're not the trustee. And to be protected from Medicaid, it has to be a full and complete transfer more than 60 months, 5 years ahead of time, someone else, and you can never revoke it. So some people say that I'll do everything to avoid probate. Okay, fine. Now the next document we're going to talk about is the power of attorney. A will takes care of your assets if you pass away. But what a power of attorney does is you're giving you're permitting a spouse, kids, family member to be able to make sure your bills are paid. Now a will is valid forever. And you look at your old will, if it still contains what you want, original signatures, it's good. Now, what we've been also doing is, telling people that, it's unless you think of controversy, give copies everywhere. Now, it's like, a power of attorney is either effective right away or only upon disability. If it's effective right away, it's a durable power of attorney. It stays in effect even if someone becomes disabled. A springing power of attorney only springs into effect if someone becomes disabled. I had a funny client. He was a carpenter, and he goes, Kenny, you're talking legal terms to me. Let's say springing and durable, and he goes, Kenny, explain to me in carpenter's terms. He goes, okay, for the power of attorney, if it's effective right away, your son can steal all your money right away because he's the person you were going to put in charge. If it's effective only upon disability, he has to get a note from a doctor before he steals your money. Knowing that, do you trust your son? He goes, I trust my son with my life. Okay, fine, make it effective right away. Now, the other good thing is, there was a law in New Jersey that some of the banks gave people a hard time that they said, oh, it wasn't on our Wells Fargo form, it has to be redone, and so the legislature came up with a statute that says if it makes reference to New Jersey statute, the bank has to honor it. However, the form has to make reference to Section 2 of PL 1991 C95 C 46:2B-11. And I'm positive those cheap forms that people find online do not make reference to that statute. That you're cheaping out, and then all of a sudden you need something on a emergent basis, and the bank says, no, this is all done wrong, signed wrong, etc. Now, a power of attorney it could be effective right away, but I do recommend people sign or re-sign the power of attorney every 5 years. Also, sign it if their address changes, their agent number one's address changes. Because again, we're trying to, it's not because we make an extra whopping $75 or $100. It's because if your daughter gets married. She's the agent number one, and she has a new name, different address, and she comes in with her ID. The bank is gonna say, "Who are you?" Well, I'm Joe's daughter. I need to. It goes, well, this is a different person on the power of attorney. Well, I changed my name. They're gonna. My job is to try to talk to you nice people and try to make things as easy as possible. Oh, and by the way, I always say that typically. Our office, other attorneys charge a $200 consult fee. If someone attends one of our programs and calls us within $200, we don't charge the consult fee. What we do is we send the person the short interview form, they email it back, and I talk to people, no strings attached. Someone says, okay, I want to get stuff done, fine. If someone says, okay, thank you for talking to me, fine also. But again, we do the free consult. Oh, and by the way, many people nowadays have like what's called legal insurance through their work, where it pays for wills, power of attorney, living wills. So, for example, there's a legal plan called MetLife. So a lot of people working at Johnson & Johnson, Barclays, Bank of America have this plan. Some other people at Johnson & Johnson have the IRAG legal plan. So, hey, talk to your employer, do you have it? We don't have a lot of time to do this program. Sometimes kids have disability or special needs, so some people, rather than we don't want them the money outright, we do a special needs trust. Don't assume these cheap forms you find online have been updated, because, hey, in New Jersey, the prior year adopted the New Jersey Care Act, where you can designate a caregiver that the hospitals have to talk to and look at, especially upon discharge. So we revised our powers of attorney to have a clause under the Caregivers Act. Now, after you sign your living will, it is a good idea to forward to scan it and send it to your financial advisors, your bank, your life insurance people. This way, they have it on their records, so it is there. All right. Okay. The last document we're going to talk about before I bring in Dave, our financial advisor, is the Living Will Advance Directive. Now, older people remember the Carrie Ann Quinlan case, where it was New Jersey became the first state to recognize someone's right to not prolong the life. And then a different case went to the Supreme Court, the Terry Schiavo case, where they looked at why it's so important to have a living will. So think of the living will as a document that you're in a coma, irreversible condition. There's no hope. You're brain dead. No hope for you to become conscious. You're giving instructions to hospitals and doctors. Hey, listen, if there's no hope for me, then these are my wishes. Follow my wishes. Remove all this support. Because again, if it's not in a living will, then the family's put on the spot. And you don't want to put your family on the spot. I remember when a doctor asked me that question on where someone did not have a living will. Okay, what should we do? Now, I knew what the right decision was for someone who's 92 years old, but you hate to be the one to say, okay, doctor, yeah, okay, let's end the person's life today. You feel bad. I couldn't even do it for my dog, when my dog was was so sick. So think of the Living Will Advance Directive is and we to make it better, we took language that the medical society has. So Section 8, fluids and nutrition to be provided or withheld. Probably 85% of the people now say, listen, there's no hope for me, no feeding tubes. Section B, directives as to medical treatment, artificial machines. 99% of the people say, hey, if there's no hope for me, I don't want to be on artificial machines, kept alive, etc. And then have my family, stuck with the deductible bills. We've also revised our documents to provide for a HIPAA authorization, so that the doctors, under the federal HIPAA law, the doctor can't even talk to the family unless there's something in writing. So let's put it in there. So again, the living will is really a document for your family, so your family does not have to suffer. You've already made the choice. In our living wills, we have a clause: organ donation yes, organ donation no. And someone's there's no hope for someone, they're brain dead, and we've always recommended the organ donor program. And I went to an interesting program put in by the NJ Sharing Network, and I asked a question. It goes, hey, by the way, I'd say, what's the maximum age to be an organ donor? They said, there is no maximum age. I goes, well, what's good on an 85-year-old guy? And they said skin and cornea. I goes, wow, I never thought about that. If I was burned in a fire, I'd rather have, old guy's skin than the stuff that got burned off me. Now, logistically, with the living will, we recommend that people, after they sign it, they scan that also, email it to family, and email it to doctors. So again, it's on there. And also in the living will, you're picking a person number one, person number two, just like your living will. The power of attorney, and just like the will. So that way, there's one person who's the captain of the ship, and it prevents someone from, if all of a sudden someone's in the hospital, the kid that wasn't involved barging into the room and saying, okay, I'm in charge now, and this is what we're going to do, because logistically they can't. Okay, let me talk briefly about how easy probate is in New Jersey. I mentioned the attorney helps the people get the original will, death certificate, check for $150, and the surrogate information sheet to the surrogate. The surrogate then sends the papers to us. The people come into our office, put their mask on, they notarize it. We send it to the surrogate by certified mail. The surrogate then sends us the letters of administration. The executor easily goes online, obtains a tax ID number, goes to the bank, sets up an estate account, works with the financial people to liquidate accounts, put them into the estate account, or sometimes if it's an easy case, they'll just they can work with the financial planner, split it into 2 shares. We have to send a notice of probate to all the beneficiaries, sell the house, and then there's no inheritance tax in New Jersey if it's going to children, grandchildren, stepchildren, but we still need to get a tax waiver. And then we prepare the release from funding bond. Everyone signs, everyone gets their money. Now let's say one of the people's a pain and they don't sign the release from funding bond. Well, listen, then no one gets their money until there's an order of the court. So every once in a while you get one of these beneficiaries that's the pain. So then what we have to do is send a letter to all the beneficiaries saying, everyone has gotten their informal accounting, everyone has signed the release of our funding bond saying, hey, we're satisfied, give us our money, except for, and it's, this particular person. And then we had to put in a letter, listen, unless this person signs, that means that nobody gets their money until everyone signs. And if they don't sign, then we have to file a complaint or to show cause in the Superior Court. All that money's coming out of then it has to go in front of a judge, and the surrogate has to do, the review of the accounting, and then no one's going to get their money for 6 months to a year. However, if the reluctant person signs the next 2 weeks, we can avoid all this expense. And by the way, the reluctant person's phone number is this, their address is this, their email is this, and the other family members get on the horn and try to get them to sign. So, that's I tried to give the expedited version of estate planning and probate in New Jersey. My name is Ken Vercammen. I'm an attorney in Edison, New Jersey. My office is at 2053 Woodbridge Avenue in Edison, but people don't even have to come to us because we work remote, and our office phone number after 10 a.m. is 732-572-0500.